Welcome to the Binary Agora. In this series, we dive deep into the world of legal tech, breaking down its challenges, its innovations, and real-world impact with insights from top researchers, also officials and practitioners. And today, we have the immense pleasure to have with us Filippo Lancieri. He's an associate professor at Georgetown University Law Center and also a research fellow at the Stigler Center at University of Chicago's Booth. So he has also written quite extensively, I would say, on digital markets, privacy, you name it, regulation. And we also thought it was a really great moment to try to discuss a bit on the progress of digital enforcement. Welcome to the Agora.
Thank you very much for having me. It's really a pleasure to be here.
As opposed to the EU model, which relies on the public enforcement, the US really stands out as one of the most, I would say, litigation-driven jurisdictions in terms of the application of antitrust rules. Which model do you think is better designed to try to remedy these structural digital market harms, such as self-preferencing, bundling, or also the leveraging of data?
Thanks. Yeah, that's a great question, a great place to start. And I think it's always important to start with like brief disclosures, right? So I'll just mention here that I have no conflict of interest other than I wrote a SEHE report a couple of years ago on the DMA and the DSA and algorithms. And that report was supported by both the French and the British regulators, as well as Google, TikTok, and Booking.com. Building on that, one of the most interesting things happening in antitrust anywhere around the world, and definitely across the Atlantic, is this rebirth of private litigation. So private litigation was really weakened in the US for a very long time. You know, people talk a lot about private enforcement, but private enforcement had really been diminished, in particular against mergers and against monopolization cases for decades now. And then in the EU, you see the birth of private litigation like happening both in the European level and in the UK level. So if you had to ask me to pick between a system, I think the hybrid system between like the mix of ex-ante regulation with private enforcement, basically what the UK is doing right now, is the best system that we're going to have and that we can develop. If you think about the many benefits that private litigation brings to the enforcement ecosystem, right? So first, you just have a lot more resources. You know, there's all this discussion about, you know, the commission has 50 or 80 or so many officials to implement the DMA. What are the sources of funding? Private plaintiffs are incredibly sophisticated and they have a lot of money to litigate, right? Think of Epic here in the US, like how much money and expertise could they bring to the table? And this both like basically complements the work of public enforcers, but it also allows you to have this increased deterrence that comes from just having more litigation, right? I think every single independent person that has looked at antitrust enforcement across the Atlantic, you know, they found that we have a chronic under-enforcement problem, and just having more litigation and deterrence is actually very important. And then there are different ways to which private litigation is also important. You know? So they are the only people who are really able to compensate parties for losses. If you think about ultimately, you know, the support of the antitrust enterprise has always happened as a result of intra-elite disputes, you know, people seeing something to win from litigating competition laws and being compensated when they feel harmed. I had my final class yesterday, and we were talking about the private enforcement case brought by the Swifties, the fans of Taylor Swift, against Live Nation. And they basically bring a monopolization claim against Live Nation, saying we really wanted to go to this show, and Live Nation prevented us from going to the show because they were scalping the tickets. So these people are really feeling harmed. They're really feeling like injured by the laws that protect them. Antitrust could provide a response. They could provide them some level of indemnity, you know, some level of compensation. And finally, they help diversify the marketplace of ideas, right? If you look at basically the American Antitrust Institute, that has been one of the few think tanks that has been pushing for stronger private enforcement in the US, has been funded by private plaintiffs. And they also help diversify the work of academics and regulators. You know, in a world where revolving doors are becoming more and more common, you want to have an off-ramp that doesn't only mean, you know, I do what the defendants want and I go work for them afterwards. Choosing between one or the other, like I would pick the hybrid. But if I have to choose between one, then I think the European model is just a much better model. And I think the Meta case is a good example. We spent 6 years in litigation to basically say that a company doesn't have market power. And for me, what is the highest success of the DMA so far is that the DMA has successfully shifted the conversation from these, you know, very convoluted debates around liability to debates about remedies. But now all the attention of European regulators, the European academic community, civil society is how we can actually design effective remedies that change reality on the ground. And this is already a gigantic success of the DMA that just changes the ball game.
As you already mentioned, the Meta case, the judge decided against the FTC's action, asking to determine that an anti-competitive behavior or monopolization had materialized because Meta had acquired its then competitors Instagram and WhatsApp in 2012 and 2014. So I wanted to ask you about what are the main takeaways for the ruling, and how do you think that it may also hurt the chances of other cases progressing in the US?
Well, actually, I taught antitrust twice here at Georgetown, because I taught it in the spring, and then I taught it again in the fall. And in both times, we actually dedicated a good amount, a class and a half, to the Meta case. And one of the highlights, which was just a fun thing, the trial was basically happening like 10-minute walking that way. So I took my students there. We could see the cross-examination, and we've been discussing, the expert witnesses. I think it's really essential to understand how we got to the situation where the court's basically saying that Facebook doesn't have market power, right? So the law in the US for a very long time has been focused on two things. To succeed in a monopolization case, Section 2 case, you have to prove that a company has power, and market power is broadly understood, the ability to influence markets, diminish innovation, diminish quality, restrict output, and increase prices. And then you have to show illegal conduct. You have to basically show, that this market power has not been acquired in an illegal way, in a way that was not a result of successful competition, investment in innovation. But these are two different prongs of the test, and this has been settled law for 90 years almost. The FTC had two complaints. So first, it had the complaint against Instagram and WhatsApp, but it also had a complaint that related to interoperability and the closing of the network at strategic moments in time. Judge Bosberg dismissed the part of the closing of the network at the motions phase. So the trial phase was only focused on the acquisition of Instagram and WhatsApp. And what this did is that it effectively restricted the available remedies, right? If the entire case is focused on whether the acquisition of Instagram was illegal, then basically the only remedy that made sense in that context was a remedy where he would require the divestiture of Instagram. And so he was really constrained on what is the divestiture of Instagram? Do I think the divestiture of Instagram is a reasonable remedy or not? Once you move to the law, you have to prove power plus conduct. And the prevailing precedent on the Meta case was actually the Microsoft case. If you remember, the case was basically about the exclusion of Netscape. One of Microsoft's main defenses was like, we basically killed Netscape, but how would we have known that Netscape would actually have developed into a meaningful competitor to Windows? And what the DC Circuit answered, which was a very powerful answer, was to say, this is not the good operational legal test for the conduct prong of the Section 2 case. What the real question to be answered is not requiring the DOJ to prove to a very broad counterfactual that Netscape will really have developed into this really scary, strong competitor, and who knows what's going to happen in these tech markets. What the real test is, did Microsoft at the time believe that Netscape was really a real threat? And did it take decisive action to basically suppress that threat? And so if that had happened, and this was enough for causality, this was enough for liability under the Microsoft case. And so you go back to the Meta case, and you have Mark Zuckerberg's email saying, it's better to buy than to compete. Trace a parallel between that email and that type of reasoning against what was a legal standard at the time, and it was basically a legal standard that was pretty differential to the FTC, and the FTC built a lot of its case around it. And so what happens then, Judge Bosberg is like, I have to basically decide whether I want a divestiture or not. And then the legal test is strongly in favor of the FTC in that case on the second prong of the conduct test. And I was really talking to my students that the trial is happening, is really going to be determined by the TikTok ban. If TikTok is effectively banned, then I think that FTC would win. If TikTok is not banned, I really do believe that Judge Bosberg is going to have cold feet. Courts are incredibly reluctant now after decades of scaremongering against structural remedies. In that case, I think the FTC actually is going to lose. And what's going to be the interesting question is, what's going to be the way through which the court is going to basically say that Facebook doesn't have market power? Most of the discussion of the Meta case has been focused on relevant market definition. Does TikTok directly compete with Facebook or not? And does YouTube directly compete with Facebook or not? I actually don't think that's the most interesting question, because I think that the definition of a relevant market in this market is always arbitrary. Most courts in Europe and regulators in Europe agree that the social graph is important in other parts of the world as well. But ultimately, there is some level of competition that's not 1 or 0 between Meta products and TikTok and YouTube and others. The real question for the court is do companies have the ability to influence markets, charge differential prices, and just have very high profits, no impact innovation? And the FTC showed during trial that last year, Meta had $160 billion in revenue, and $87 billion in operating profits. Like if you think about market power as the ability to earn super competitive prices, that's the textbook definition. Someone has to amend Wikipedia and like basically rewrite the learner index and rewrite all the case books we have about market power, because like this level of profits are basically the textbook definition of market power. And another thing that the FTC showed, for example, was that the amount of ads that people see on Facebook or on the Facebook platform is really correlated with the age of users. So if you're a young user where you're really switching between TikTok and YouTube Shorts and Reels and things like that, you actually see very little ads. You see around 4% of ads in your feed. But if you're an older user, 30 or more, then you basically see 20% of ads in your feed. This case was defined by the legal standard. So basically what Judge Bosberg concluded is that he merged the two prongs of power and conduct, and then he created a new standard that has never been seen, I think, in US antitrust law, to say, the definition of whether a company has market power or not has to incorporate whether there was illegal conduct on the second side. Basically like running away from the DC Circuit precedents without actually directly addressing it. Now, the most convincing evidence that he saw was this really interesting experiments ran by John Liston, where he just paid people to get out of Facebook and Instagram and try to track where do people go. And basically what John List showed is that people go more or less to the same level from Facebook to Instagram to TikTok and to YouTube. But these are very small margins. The substitution adds up to like around 20% of people's time. Where did people spend most of their time? After people were paid to leave Facebook, 40% of the users went to watch the sunset. They went to off-device time. 15% of them went to watch games. 10% of them started browsing the web. 60% of them called their mothers and went to communication. And 4% of them went to entertainment. The vast majority of users supported the case to say, this company clearly has market power. When people are paid to leave, they just go watch the sunset, and we don't think the sunset is a good competitor to Meta. But ultimately, the court bent like a pretzel, merged everything and said, there's no evidence that Facebook has market power. And this is just a bad evolution, I think, of US antitrust law overall.
On the topic of interplay between not only cases, but also jurisdictions at this side of the Atlantic. So although we don't have so much private enforcement on antitrust, we have already seen that there's much interest in applying the DMA privately by individuals before national courts of the member states. There have already been rulings being turned out by some courts. For instance, the Mines regional court is the first example of one such judgment, where it basically decided on how the Gmail and also the Android OS and how they cannot be tied, and that was an application of the DMA. Individuals are also trying to pose quite interesting actions. We already know that the DMA is not about pursuing the protection of an undistorted function of competition, but rather that it aims to pursue this objective of contestability and fairness. Most authors believe that the damages directive would not apply to it because it's not competition law. But some complainants have really tried to trick the system and say, okay, we're going to apply like both laws in parallel. We're going to allege that this conduct implemented by Google, by Meta, by Apple infringes Article 102, so the prohibition on abuse of a dominant position. And if that does not apply, then we will apply the DMA. So I wanted to ask you two questions. The first one, what do you think about this type of hybrid actions that can emerge within the European context, and also whether you see that these cases trying to pursue private enforcement of the DMA are going to impact the US cases?
I forgot to answer what is the impact on the other case they are pending. It's very hard to say the impact of the Meta case, because the Apple case, for example, is built on a very different theory of harm. And these decisions are so judge specific. Here in the US, if you get a judge appointed by like Bush or Obama or Clinton, normally you have a really hard time with liability. If you get an older judge or a newer judge, like a Biden or Trump judge, it becomes very idiosyncratic. It's going to be hard to see unless the appeals court issues an opinion to see the evolution. On the questions about the private enforcement on the DMA. So I'm not the best like procedural legal person. I would almost revert to, like does the damages directive apply specifically to these cases or not? For me, what is interesting is to think about the design of the system from a more theoretical perspective, and it has been a long time this sort of scaremongering to say that antitrust cases are so complex that basically how can you actually do them through private enforcement? We need the sophisticated authorities to bring these cases. And there is some truth to that in the sense that authorities can bring better cases. They are sophisticated. But also antitrust cases are no more complicated than a complex environmental torts case or a complex IP litigation case. There was actually a lot of funding from the industry to try to promote this idea, private plaintiffs are just as unsophisticated people who don't understand the law. These have mostly been based on like very theoretical models or anecdotal evidence, and they're not based by hard evidence. The best study of U.S. private enforcement was actually done here at Georgetown by Steve Salop, and they did a pretty comprehensive review around the 70s and 80s, and they basically refuted the claims, empirically. Their data basically doesn't support the claim that these are unsophisticated people. And you should go in there in Europe to talk to Damian Gerardin or the people at Hausfeld and call them out in a debate. They're going to get a beating. Actually, I'm very happy to see that part of the design of the damages directive, if you go back in time, was the idea of the growth of European private enforcement molded by scaremongering by the Americans. Like the ABA would go there and say, this is a terrible system. We should never replicate our class action system. And so seeing that private plaintiffs are sophisticated and they are trying to merge and navigate the complex, procedural questions that arise in these cases is unsurprising, because ultimately the separation between the DMA and competition law is practically important, but theoretically weak. They're trying to accomplish very similar things. They have different regimes for liability, and the law, of course, matters. But exactly because private plaintiffs are sophisticated, they'll try to find ways in which they basically claim everything and try to use the different types of venues and the different types of arguments they can bring to make their case stronger. And courts, I think, are starting to acquiesce to that reality. What I think would be one of the most interesting developments in Europe, and is connected to your question, is connected to the broader political economy question, is that now private litigation is becoming stronger and stronger and stronger. At what level you're going to switch the rationale, and you're going to start having basic specialization by member countries to provide different types of rules for private plaintiffs. We're starting to see this in Portugal, in the Netherlands. The UK has this major development of private enforcement as well. So much of these specific rules of litigation are really left for member states. How exactly do you implement the damages directive? Or how do you actually have an actual meaningful case under EU law is still determined by member state law. Our courts really tackling standing rules. Ultimately, what you're going to see is the breakdown of these artificial barriers between Section 1, Section 2, and DMA. What I think is it's really an exciting time to be an antitrust scholar and a lawyer, right? I was just telling my students, we went to 30 years where there are basically no cases in the US, at least. At some point, some people asked Obama officials, why haven't you brought a monopolization case in 15 years? And someone said, there are no monopolies in the US economy. Now we're at a moment where we're talking about public versus private enforcement, hybrid systems, how do we implement laws in different countries, a lot of litigation in many different areas. It's a fun time to be a competition law scholar and a good time to be a lawyer.
Building on this idea of being it's a fun time to be a lawyer and also an antitrust scholar, I guess that it's also a conflicting time to talk about geopolitics. Actually, I just read that the US was trying to convince the EU to temper down its digital rules in exchange for it lowering its tariffs on aluminium and steel. There is a sense that there's some bartering going on there. I wanted to ask you, how do you really perceive this narrative that the US administration is trying to put across in terms of innovation can be really trumped by regulation regarding digital markets? Therefore, we must eliminate any kind of rule applying to a digital platform.
When we published the Stigler report, we actually had a report on politics and the political power of tech companies. And we basically talk exactly about this. Tech companies have multiple sources of political power. They have membership power, which is to use their adjacent. Think of Mozilla coming to the defense of Google. They have incredible amounts of money in a way that is almost unparalleled in history, how much money they have for lobbying. But they also can build on their complexity. They can undermine remedy design because they can just gain remedies one way or the other. And they have media power. They actually have the ability to try to shape public information by the way they present information, by the tweaks of algorithms. And then the final argument that we made is companies, in particular for the US, they actually have what we call national champions power. At some point, companies will try to, if they're losing on every other dimension of the public opinion debate, they're going to try to rally the US government to their defense. And because they are so important for the US economy, it just became even more important. This is going to create trade tensions with other countries because the US is going to start pressuring smaller countries like Brazil, like South Korea, like the EU, smaller countries. Very big jurisdictions still. And this was 6-7 years ago. I think that we've been fully vindicated after 7 years. And I actually have a new article with Stefan Bechtold and Laura Edelson, where we try to think about a framework about this international competition. It's called AI Regulation, Competition, Arbitrage, and Regulatory Capture. And basically what we're trying to do a framework is how do we think about companies trying to play this geopolitical game by pitching regulators one against the other in kind of like a race. I think the real risk of this dynamics is that regulators get too locked into this like race style competition and forget the fundamentals of the regimes and what they're trying to accomplish when these regimes are coming by. So antitrust policy is economic policy. It has to basically react to economic realities and economic priorities. There has to be some level of influence. Antitrust policy is not an independent science that is impermeable to politics. But also, I think it's important to remember that this doesn't mean that all the lobbying goes. And in this discourse between innovation and competition, I think that's exactly when there's a lot of room for weak studies and white papers and disinformation that ultimately divert the attention of policymakers and civil society from the really key questions. There was this really good Monty Python sketch, which was basically like, what have the Romans ever done for us? And Tomas Valetti actually has a good paper where he talks about what have the consultants ever done for us in antitrust? And he looks at the history and the papers published and says not much. I think the question here for this area is like, well, what has US big tech ever done for Europe? What kind of the messages that are being pushed by tech companies on this like basically fundamental divergence between regulation and innovation? Is this really going to yield better businesses for Europe or not? And I think the answer most of the time is no, right? Most of the relationship has been an extractive relationship. And so ultimately what we need to keep in mind, which is how much this whole process has backfired on US companies. Like I actually see the ultimate appeal of using the US government to try to squash European or Brazilian or South Korean regulations as a sign of weakness, not as a sign of force, because if they could win the debate on the public opinion debate, they would not use it. They have been losing on that debate. And so they've been trying to use like the big guns of the US government to strong arm jurisdictions into basically doing their bidding. This is also leading to a more clear vision for Europe that like Europe is too dependent on US technology. All the German government most sensitive data or Spanish or French runs on Amazon or Microsoft servers that can actually be used by the US government. We know that they have privileged access to this data. It's just giving a new breath to the debate that once you think about antitrust enforcement, regulation, and industrial policy, you have to think this in an integrated matter that ultimately looks at like what's the level of sovereignty that Europe wants to have and what kind of role it wants to play in the world. European determinations on that question should be driven by conversations about strategic sovereignty and tech dependence much more than should be driven by strong arming by a Secretary of Commerce or someone else.
And to wrap up the episode, maybe from this task ahead of us relating to this false dichotomy between innovation and regulation, do you think that's really taking recourse to the available economics within antitrust enforcement will or combat in some way that narrative, or what do you think is the best or policy option that we have before us?
I don't think it's a one or other like yes or no debate. It's actually about modulation of regulation and how, for example, antitrust enforcement in the US and the imposition of structural rules has really spurred innovation, right? Google innovation came after the Microsoft litigation. The AT&T litigation has spurred decades of innovation that basically impacted every single part of the US economy, almost, of the new tech economy. There's a fascinating paper by Laura Edelson talking about the AI race and how basically Google actually developed the underlying technology for AI much earlier. OpenAI did it, but they basically realized that it would cannibalize their search results, and so they basically suppressed it. And so it took someone to basically take the technology and reapply. And now we're seeing this gigantic burst on the AI race. For me, what is the most interesting part of the AI race is how much it shows the amount of rent extraction that existed in digital markets over the past decade. Now that companies truly believe that they are in competition, whether it's going to turn out or not, it's going to be a good investment or not. That's something that I think nobody knows. But companies now really believe that they're in competition. And the results that we're having, instead of like just distributing hundreds of billions of dollars in profits or sitting on this cash, they're investing hundreds of billions of dollars into actual investments. It's just lifting GDP growth in the US and across the world. So think about that counterfactual, like where we have been for the past 10 years, where most of this money was basically either sitting somewhere or leading to like So there's like meaningfully differential R&D. I think there are two ways to think about the dichotomy between innovation and competition. One way is to think about what I would call the retail level, like when you're going to look at the Apple antitrust case, can we fundamentally decide what is the role of antitrust versus innovation versus security in that case? And the answer is no, right? Basically, you can throw in as much money as you want, But this system is a system that is just like fundamentally unbalanced against antitrust enforcement. Because if every case costs 40 million euros to bring or 20 million euros to bring, and resources are just disproportionately allocated between regulators and private plaintiffs and the defendants because they are the largest companies in the economy, then a system that just tries to decide retail case by case the trade-off between innovation and competition by relying on economic studies is a system that always misses the forest for the trees and is ultimately going to lead to under-enforcement. That's a great point that was made by Ramsey Woodcock. He has a paper called The Hidden Rules of a Modest Antitrust Enforcement System. I think the good use of economics will come from is actually thinking about these trade-offs at the wholesale level, like how do we think about setting presumptions? How do we think about establishing broad interoperability rules for the economy? How do we think about the setting of the obligations in the DMA? And that's an area where you just have much higher returns to all the knowledge that is produced, like if you have better understanding how interoperability or let's say vertical prohibitions, like these unbundling obligations ultimately tend to spur innovation on the economy across the board and not trying to look sector by sector by sector, then economics plays an incredibly important complementary role to shape these public opinion conversations. And I think that's what's going to do more and more as we move towards like antitrust being part of overall economic policy and industrial policy.
With that, I wanted to thank you, Filippo, for accepting the invitation to join us at the Agora. And thank you so much for all of your insights. And thank you very much for joining us.
Thank you so much. It's really a pleasure. This was really a fun chat. It's always very nice. And I'm looking forward to seeing the next episodes too. I'm following the series and it's awesome.